Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
I want to talk to you today about the conceptual framework for notice and termination of employment. For those of you who are human resources professionals, some of this is going to be old hat. Feel free to doze. The message here is that there is no legal entitlement to reasonable notice. And to understand why that's the case, we need to understand the theoretical framework within which the law of termination, and we're talking about termination of employment by the employer without cause. There are two parallel schemes. There's a statutory scheme that deals with notice of termination. None of the statutory entitlements could be considered to be reasonable, and they vary dramatically from province to province and between the federal government and provinces. We're going to go through that very quickly because it's something that generally doesn't concern us. Most companies are familiar with it. Lawyers are rarely called in to help with statutory issues. More important and more complex is the common law notion of wrongful dismissal and how that works, and we're going to move on to that. So we start with the, let's see if this thing works too. So the statutory notice requirements for termination of employment without cause. For provincially regulated employers in Ontario, it's the Employment Standards Act 2000. For federally regulated employers, and these include banks, telecommunications companies, interprovincial transport, things of that nature, it's the Canada Labour Code. The Employment Standards Act, Ontario provides notice requirements beginning at 3 months on a sliding scale that maxes out at 8 weeks. So that's it for the statutory requirement in Ontario. The Canada Labour Code, a 2 weeks notice period, that's where it ends. So there's nothing reasonable generally about either of these. Both statutes also talk about severance. So when we talk about notice and compensation for loss of a job, we can't ignore severance. And again, there are different requirements. The Employment Standards Act is relatively generous. It provides up to a half a year's salary as severance. However, it doesn't kick in until the employee's been with the company for 5 years, and it only applies to employers with larger payrolls. Federally, 2 days regular wages with a minimum of 5 days. So it's 2 days for each year, minimum of 5. Not very generous. Common law considerations. The thing that we really need to understand about employment law in a common law context is that it's a contract. The relationship is one of employer and employee. The employee provides the services, the employer pays for it. Very basic. It's voluntary. The parties can set their own terms within certain limits. One of those limits is that the statutory minimum notice provisions have to not be violated in a private employment contract, or that contract won't be enforceable, at least as far as notice goes. There are other statutory requirements that also may not be violated, human rights law, occupational health and safety, and so on, but they don't really address termination or notice. The law of contract applies to an employment relationship, and wrongful dismissal and the finding of notice and the award of damages is breach of contract, and that's very important, and we'll see why. The terms of the employment contract. It won't be a surprise to you to know that this doesn't happen very often. We rarely see detailed employment contracts. There are a number of reasons for that. One of them is that an employment contract is a bit like a prenup. You know, when you're talking about dismissal and termination and compensation before you've even gone on the honeymoon, that's a very difficult thing to do. Another reason is that very often employers really don't care. You know, they want somebody, they want that person. They are not going to damage the relationship by setting out terms of divorce at the beginning of the deal. So very often what we have is a simple written job offer, and that forms the basis of the employment contract. Sometimes we don't even have that. It's just a verbal arrangement. The result of this is that the contract, and it is a contract between the employer and the employee, very often doesn't contain all of the terms. It may or may not address pensions, it may or may not address vacations, it very often doesn't address what happens when you can't stand the sound of her brushing her teeth. So, so we come to termination. And again, the contract governs. Subject to the statutory minimums, if you have a contract that says that if you're terminated, you get 6 months notice, or 6 months pay in lieu of notice, that's what you get, whether or not that's reasonable. And you cannot go to court and say, hey, I'm entitled to reasonable notice. Let's ignore the contract, because the courts won't do that. Where the terms of the contract just aren't there, then the courts have to fill in the gaps. And this is where we get to the doctrine of reasonable notice. Those filled in gaps are referred to as implied terms. They're actually inferred, but they're always referred to as implied terms for some reason. What is wrongful dismissal? Well, technically, it's the termination of the employment by the employer without just cause. Just cause is a very rare event, and it's not the subject of this particular talk. But I will just add that the statutory requirements also do not apply where there is just cause. So just cause, no notice, no statutory notice, no common law notice, no damages. The Supreme Court of Canada describes wrongful dismissal this way. An action for wrongful dismissal is based on an implied obligation in the employment contract to give reasonable notice of an intention to terminate the relationship in the absence of just cause. The Supreme Court's definition refers to an implied obligation to give reasonable notice. Now, there's only an implied obligation if there's no express obligation. That is why there's no legal entitlement to reasonable notice on termination without cause. If there is an express agreement, nobody's going to imply anything. The agreement is there and the parties are free to contract. But let's get through this. In the absence of express agreement, the court will infer as a term of the contract that the parties intended that the contract, if terminated unilaterally by the employer, may be terminated but only on reasonable notice to the employee. So that brings us to the difficult question of what is reasonable notice. The common law test for reasonable notice in Canada was established in 1960 by the Ontario High Court in Barber versus the Globe and Mail. That case has been affirmed in all jurisdictions, I think including Quebec, and by the Supreme Court of Canada. And this is the test. The reasonableness of the notice must be decided with reference to each particular case, having regard to the character of the employment, the length of service of the servant. Is that nice? Servant? 1960. The age of the servant and the availability of similar employment, having regard to the experience, training, and qualifications of the servant. That was a test established in 1960 and is still referred to in almost every wrongful dismissal case to date. There have been a few glosses on it. It had been thought that employees who were more senior in their position, presidents, vice presidents, would be entitled to longer notice. The Supreme Court recently has said that's not the case. You have to look at those factors and only those factors. Problem is, it's not terribly helpful. The courts insist on that each case must be decided on its own merits, looking at all of the four tests, and there is no rule of thumb. Well, that's what they say. What we do is we do statistical analysis of wrongful dismissal awards. We have access to databases that break down the body of judgments in terms of the four Bartle conditions. So if we have a client who wants to terminate somebody, we can get a look through computer-generated statistical analysis of where the case law might fall. And not surprisingly, there's a pattern because the law is actually fairly consistent. The pattern clusters around 1 month, 1 month's notice for each year of employment. It's not technically a rule of thumb. It doesn't work on the short end. It doesn't work on the long end. But in the middle, it's a pretty reliable starting point. Awards in excess of 2 years, very rare. The implications. Because the relationship is a contract, a whole lot of consequences fall from that. I'm going to go through some of them. First of all, it's not illegal to wrongfully dismiss someone unless you breach the statutory guidelines. It's just a breach of contract. So there is no legal obligation to remedy that breach. The remedy for breach of contract is to sue, and not everybody does that. it's certainly open to an employer to provide the statutory minimum and wait and see. Mitigation is a huge issue in wrongful dismissal law. If a terminated employee does choose to sue, he must establish that he's made reasonable efforts to find alternative employment. That's a contract requirement that you cannot sue for damages for breach of contract unless you've taken all reasonable steps to mitigate your loss. Again, contract is the conceptual framework. If the employee fails to take reasonable steps to mitigate, he may not be entitled to damages at all, even though he was wrongfully terminated. It sounds obvious, but it bears repeating. It is in the best interest of the employer that the terminated employee find a new job as soon as possible. The employer benefits as much as the employee does. The obligation to provide pay in lieu of notice, if there's no notice provision in the contract, will end. And so really, it's like the employee with a new job is working for his old employer. The financial relationship is one-to-one. And again, let's not forget the entitlement is to notice, not to a package. If you are doing a package, many employers do as a matter of course, either because they think it's the right thing to do, because they've been advised by their lawyers to do that, because their employees expect it, it's standard in the industry, all kinds of reasons. Remember when you're constructing one, that those cases that we see part all in those other cases, these guys were unemployed for years. You know, they didn't find jobs within what would be the notice period. They went through probably 5 years of litigation to get to where they got. They're not typical. So really, it's reasonable to think that, you know, the case law, that is what happens if there's litigation. But there usually isn't litigation, and usually when there is litigation, it settles. So I would take the 1 month a year or whatever your statistical analysis works out to, and I would treat that as the high end on a package. That's just what I just said. So if you are constructing a package, you know, it's certainly reasonable and appropriate to lowball relative to the reported cases. It's also useful to construct your package so it encourages the employee to mitigate his loss to find another job. There's lots of things that an employer can do: employment counseling, reference letters, time off for interviews, and financial incentives. So very often in a package we will provide that if the terminated employee finds another job, here's the financial reward. Very often it's a lump sum payment. Common one is half of the remaining salary continuation. So again, that's constructive, and it's working toward a solution that works for everybody. We're almost at the end here. Avoid unnecessary complications such as demanding a response within a reasonable time or insisting upon a release. You know, there are circumstances where these things are appropriate, but usually they're not, because you're faced with the question, well, okay, he didn't respond within 7 days, now what do I do? Don't make threats you're not prepared to keep. And again, a release, maybe it's useful, maybe it isn't. You know, if you know you have a certain obligation, if you're throwing the ball into the short end, pay it anyway. You may or may not sue. The release doesn't really help. And again, always look for a win-win solution. So, no legal entitlement to reasonable notice, but we talk about it all the time. Thank you.
Thank you, Bill.